Good evening, everyone. I'm Professor Michelle Foster. I'm the Dean of Melbourne Law School, and it is a great pleasure to welcome you to the 2026 Baxt Lecture. I'd like to begin by acknowledging that we're meeting this evening on the unceded lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to elders past, present and emerging, and extend that respect to all Indigenous people who are joining us this evening. Well, the Baxt Lecture is an annual public lecture series of the Melbourne Law School's Competition Law and Economics Network, named in honour of the esteemed competition law professor Robert Baxt, AO Emeritus, in recognition of his substantial contributions to the developments of competition law in Australia. Bob Baxt was an Australian lawyer and chairman of the Trade Practices Commission, the government agency preceding the ACCC, from 1988 to 1991. He was Dean of Law at Monash University and a Professorial Fellow at the University of Melbourne. Bob also served as Chair of the Advisory Board of the Competition and Consumer Law Specialty in the Melbourne Law Masters program for many years, generously sharing his expertise with us. In his honour, this lecture series highlights big-picture policy debates on competition law issues across Australia and internationally. I would like to offer a very warm welcome to members of the Baxt family who are with us this evening. Ruth, Bob's wife, their daughter Miriam and their granddaughter Michaela have joined us this evening. And I want to acknowledge the family's continued support of Melbourne Law School in the tradition of their late husband and father. And of course, a very warm welcome to our guest speaker tonight, Professor John Newman of the University of Memphis School of Law, who will be more fully introduced in just a moment by my colleague Wendy Ng. A word about the presentation for this evening. So we're going to hear, as you're about to hear, a wonderful lecture. There will be a chance for you to ask questions, so please do think about your questions as you're hearing the lecture. We'll have a roving mic and there'll be that opportunity to put your questions to the speaker. Finally, there will be a vote of thanks from my colleague Wendy Ng. I want to also remind you that the lecture is being recorded and will be available on the University of Melbourne Law School website shortly. But now it's my pleasure to welcome my colleague and Director of the Competition Law and Economics Network here at MLS, Associate Professor Wendy Ng, who will introduce our guest speaker and the evening's lecture. Thank you so much, Wendy.
Thank you, Michelle. Hello, everyone. It is lovely to see you all here in person at the Law School this evening. We are delighted that Professor John Newman has accepted our invitation to deliver this year's Baxt Lecture. He holds the Herf Chair of Excellence at the University of Memphis School of Law, where his research focuses on anti-monopoly issues. He's published widely in a number of leading academic journals, and he has also been interviewed by a variety of media outlets, ranging from the New York Times to the Rolling Stone. Professor Newman has also served at both the US Department of Justice and most recently at the US Federal Trade Commission. It is this combination of academic rigour and enforcement experience that Professor Newman will bring to today's lecture, where he will speak about and reflect upon his experiences being part of the anti-monopoly movement in the United States, which has gained much prominence and influence over the past decade, not only within the realm of US antitrust law, but also in other countries around the world. And as many of you will know, what happens in US antitrust law will often have direct and indirect influences and impacts beyond its borders, including in Australia. So please join me in welcoming Professor Newman to the lectern.
Well, thank you so much for the chance to be here. I'm very excited to share a little bit of my experience. Thank you for that glowing introduction. Over the past, I think 10 years feels about right. There is, as Professor Ng pointed out, a change, a sea change that's been occurring in the US, and as Professor Ng also points out, those changes often do have reverberations. Sometimes we get positive feedback loops, sometimes negative. So it's a chance, I think, now that this movement has had some time in power and now has had some time out of power. It's a nice opportunity to reflect back on what's happened, some of the things that have gone right, some of the things that I think went wrong, and talk about lessons learned from this movement. So with that, this is a somewhat unusual photo, perhaps, to choose for a talk that's titled Revolutionaries in Power. Not a particularly revolutionary group, except for perhaps this person right here. This was my former boss, Lina Khan, who was named head of the Federal Trade Commission by President Joe Biden in 2021. Just to kind of roadmap us before we dive into what she did and some of her contemporaries, including myself, did during this brief moment in power. First, I want to talk about the rise to power. How did this happen? Lina Khan, 33-year-old at the time, kind of wunderkind rising star scholar, at the helm of a federal agency, a federal antitrust agency. She brought along people like me who just didn't look like the traditional heads of agencies, right? We were just a little bit younger. We maybe had a little bit more of a chip on our shoulder. It was a very unlikely ascension. I want to talk a little bit about this unusual confluence of events that led to those folks being put in power. And then I want to talk a little bit about some wins. I won't do a victory lap. I don't think that would be appropriate, but we did do some good things during this brief period in power. I want to spend some time talking about some of those. I also do want to talk about some of the mixed results, some of the losses that we took, and some lessons that I personally learned along the way. And then finally, I want to hopefully end on a hopeful note. I want to talk about what we've been doing while out of power, hopefully building toward a better future than the one we currently inhabit in the US, which, probably no surprise to anyone in the room, is not a particularly bright one from my perspective. So, with that, an unlikely ascension to power. How did this happen that Lina Khan, Jonathan Cantor, Rohit Chopra, and a crew of like-minded individuals came to head up a US antitrust agency? Well, one thing that happened was that macroeconomic and political conditions in the US reached a very unusual moment by 2020, even by 2016, I would argue. But we had a huge financial crisis and then a widely perceived to be failure of policy in response. Right? Now, that wasn't the view shared by everyone. There's certainly a wing of the Democratic or Labor equivalent party who views President Obama's time as a resounding success, but there was a growing feeling among at least some of us that it was not a success at all, that it had allowed economic conditions to fester that were leading to popular unrest, that were leading to an undue concentration of corporate power in the US, and all of that was, we perceive to be at least, a big problem for society. There was, at the same time as macroeconomic and political conditions were kind of leading to an unusual moment, there was a lot of intellectual groundwork that was being done by people like Lina Khan. People, I think, sometimes perceived her, and certainly I've encountered people in the US who perceived her to have just exploded onto the scene in 2020 out of nowhere. Far from it. She was doing deep industry research into concentration and corporate power problems as far back. I've got an article by her published in 2013. She was doing it as far back as 2012. So long before 2021, when we took the reins, she was thinking hard, thinking deeply, and researching in a very applied way, as a journalist, really, corporate concentration in the US. So intellectual groundwork. The COVID-19 pandemic plays, I think, a large role in all of this. All of a sudden, a large percentage of the US populace and the global populace was encountering the world in a very intermediated way. And although it could sometimes be hard to convince people that big tech was a big problem before the COVID-19 pandemic hit, all of a sudden when everybody was encountering the world very much through big tech firms, at least in the US, I think it thrust that concentration of power to the fore. And this was something that Lina, that I, and others had been researching, writing about, and trying to raise the alarm about for years beforehand. So that was an important driver in all of this. All of this together, I think, led to an unlikely president to do this, Joe Biden, no wild-eyed leftist, right? But feeling, I think, some pressure from the electorate base, feeling some pressure from an insurgent left wing within the party. Bernie Sanders, Elizabeth Warren, among others, had been putting pressure on the more centrist party. All of that led to what was described as President Joe Biden taking a big left gamble, putting someone like Lina Khan, someone like Jonathan Cantor, in charge of federal antitrust agencies. An unusual confluence of events that led to an unlikely set of people being in power. Okay, so what did we do while we were in power? Well, I want to talk just a little bit, before we talk about the wins and the losses and the mixed bag results, I wanted to talk just a little bit about the task we faced as I saw it. And at least in the US, we have this sort of saying about building a parachute after you've already jumped out of the plane. That was kind of the task in some ways. It was an extremely broad mandate. Now, our mandate, to the extent we had one, I think was something like apply a radically different approach to turn the tide on corporate concentration in the world's biggest economy. Okay, no small task. But by the way, although this movement had been around for something like, let's say, 5 years in a real coalesced form, that is not a lot of time in terms of usual intellectual movements in schools. Right? It was just a very young movement in a lot of ways. Now, I do think we had an easy target. US antitrust or competition enforcement had become very narrowly constricted. Basically, all enforcers were doing was trying to stop some of the worst horizontal mergers among direct competitors. I'm trying to think of a rough Aussie equivalent might be if like Woolies and Kohl's merged. Like, okay, let's stop that one, right? But that was it. That was basically all enforcers were doing. And then occasionally going after monopolies, single firms that had become too powerful. But even then, the cases were fairly narrow in their scope, and the remedies that enforcers were asking for were quite narrow and frankly unable to deal with the actual power that was underlying the problem. So we had a very constricted establishment. It was just obviously doing too little. That did, I think, make things a little easier for us. But that narrow, constricted scope of US antitrust law was something that we had basically been criticizing, critiquing, but candidly not suggesting an obvious replacement for. We had mostly been doing deconstructionist work, in other words. Easy target, right? It was satisfying work to do. But the project of building a positive vision of what a new anti-monopoly movement would look like in practice, I think was something that really hadn't been done yet. And again, it was a very young movement, so it may be forgivable that we didn't have a fully baked vision, but we didn't have a fully baked vision. So this was the task then, come up with a vision, right? Figure out what the goals are, what are the metrics we want to use to measure success, what are the priority targets, all of that. I think we needed to basically figure out on the fly. So with that, I think given the mandate and given the lack of a parachute when we jumped out of the plane, I think we did okay. I want to talk about some of the wins, some of the big firsts that we accomplished in a relatively short period of time, roughly 3 years in power. We filed the first attempt by a US anti-monopoly enforcer to stop any big tech acquisition. 5 firms had acquired something like 1,000 firms, and we hadn't tried to stop one of them. We tried to stop one of them. I think that's a win, even setting aside the result. Just throwing down a gauntlet and saying, we are going to try to stop some of these, I think sent a pretty big message. So I think that was a win, even just bringing that case. We in the US had not tried to stop what we call a vertical merger in competition lingo. It's a merger or acquisition between a supplier and a customer, rather than direct competitors. We in the US hadn't tried to stop one of those for something like 40 years. We at one point in 2022 were challenging 3 of them at once. That hadn't happened for like 70 years. And our friends at DOJ were trying to stop another one. So all of a sudden there was just a lot of activity around these types of mergers. I think that sent a big message. We have laws against harmful price discrimination, charging different prices to different customers in the US, but they just hadn't been enforced for, again, something like 40 years. We brought the first price discrimination cases in 40 years. Interlocking directorates, so one person sitting on the board of directors of 2 companies who compete against each other. Seems like an obvious problem. We have laws against it in the US, but again, they hadn't been enforced for something like 40 years, just 0 enforcement. We went after some of those. Our Department of Justice has authority to bring criminal cases against monopolies. It hadn't been used in 60 years. DOJ brought the first criminal monopolization case in a really, really long time. We had gotten obsessed with protecting consumers, which is good, right? Nobody likes paying high prices. We in the US, though, had forgotten about a whole other constituent, workers, right? Workers are an important beneficiary of competition. And when companies collude, sometimes they set higher prices to consumers. Sometimes they set lower wages to workers. And yet, in the US, we had never tried to protect workers using anti-monopoly laws. In fact, much the opposite. We had been attacking workers who tried to organize, calling it a cartel. This was a total inversion then to bring cases to try to protect workers from anti-competitive, harmful practices. And then somewhat similarly, we had never tried to block a merger between two companies on the theory that it would harm workers. We had certainly tried to block them based on consumer harms, never workers. The FTC brought the first ever in its 114-year history case to try to stop a merger because it would harm unionized grocery store workers. So a lot of firsts, and I could go on, I won't. I try to be a little modest here, but I do like bragging about this track record. I do think we did a lot of good, again, in a very short period of time. It wasn't all running around protecting workers. It was some painful mixed results and losses as well. I do, though, want to spend just a little bit of time talking about some of the less obvious things that I'm going to brag again for just a second, but some of the less obvious good things that happened. One, because of all that activity I had on the screen just a moment ago, a lot of the really bad, like really harmful mergers never made it out of the corporate boardroom because they were suddenly looking at an environment when we had real enforcers on the beat, a cop on the beat, right? Okay, well, let's just not even try the merger. We didn't get a lot of headlines for that. This was one nice story we got. You don't get as many headlines when deals don't even make it to the enforcement agency. But I would view this as a huge success because now we don't even have to spend taxpayer money trying to stop these harmful mergers. We just stop them before they start. I think that was a less noticed but really important outcome. Drilling in on a couple of companies in particular, these are acquisitions by Alphabet and Meta over time. This is when I joined the agency. This was my first year at the agency. I view that as a success. Right now, that's a little bit flipped. Not every acquisition by these firms is harmful, but when they have as much monopoly power as they do in as many sectors as they do, a lot of those acquisitions were harmful and should have been stopped. So I do view that as a win as well. We also got companies to start, this is a little hard to read, but we got companies to start just abandoning mergers as soon as we threatened them with a lawsuit, so we didn't have to go all the way through a trial. They knew we were serious. They knew we would go all the way through a trial if we needed. So instead of fighting us, they just said, all right, we'll just abandon our deal and walk away. And we don't get as much publicity when we don't have a big splashy trial at an agency, but again, I view that as a win. It's saving taxpayer resources. It's stopping harmful deals. And then, I'm in academia now. I can't not talk about the effect on law students. When I first taught a competition law course in the US, I had 3 students in my class. It was great. We had a great time. I got to know them very well. The last time I taught a competition law course, which was now a year and a half ago, I had 140 students in my class. That is basically the Lena Khan effect, right? She, along with Jonathan Cantor, brought big, popular, interesting cases. They also spent a lot of time engaging with the public. They spent a lot of time traveling to the US law schools, visiting classrooms, right? And that was not just because they enjoyed talking with students, they do. But it was because they saw that as a really important building of a pipeline project. I view that uptick in interest as a really significant, if under-recognized, win as well. Okay, now I'll stop bragging. A few mixed results. First off, I mentioned that first case we brought to try to stop a merger or acquisition by a big tech company. It was a case against Meta. They had attempted to buy a virtual reality app studio that made a much-loved fitness app. Keep in mind, this is still in the COVID-19 era when working out in a virtual world without having to leave your apartment was like a pretty big deal. It was pretty important. So we felt like it was a significant case. We lost it. Meta made that acquisition, but along the way, we dusted off some old legal theories that could be used the next time around, and I think that sent a pretty strong signal to the industry that, hey, the law was pretty dormant for a long time. It's now dusted off. It's ready to go. So sure, propose us the next merger, and maybe we'll lose that one too. But we've now, I think, kind of thrown the first stone, let's say, cracked the glass a bit. So I think a mixed result there. We ultimately lost our case to break up Meta. Why do I treat that as a mixed result? Well, the previous administration, President Trump, first time around, had filed a complaint to try to break up Instagram. That complaint got dismissed. So one of the first things my old boss, Lena Khan, had to do was fix that case, essentially. We did that. We got that case headed toward trial. We then went out of power. The agency went to trial, lost the case. So it's kind of a mixed result in the sense that at least while we were there, we saw some success, even if at the end of the day, the company remains intact. And then there were some losses, right? Just pure losses. We tried to stop the $70 billion acquisition of a video game company, Activision Blizzard. If we've got any Call of Duty or World of Warcraft players, that's the studio. Microsoft, makers of Xbox, tried to buy them. We tried to block it. We lost. That one stung. It was just a bad loss. I can complain about the judge. I do think she was a bad judge. I say that jokingly now, but her son works for Microsoft. Feels like a conflict of interest to me. She's felt like she could give us an honest, fair shake. I don't think she did. But complaining about the referee is just not going to get you the win, right? We took the loss. That was a big loss. It hurt us. And what was worse, it ended up, I think, stinging some of our friends overseas. The UK CMA had tried to block this one too, and I think they dealt with some blowback after the deal went through. So it was a stinging, punishing loss. Our friends at the Department of Justice in the US lost some cases as well. They had tried some vertical challenges against mergers involving healthcare. They lost a couple of those. We lost a case trying to protect competition among mattress retailers. It wasn't a huge case, still hurts to lose. So there were some losses along the way. I don't want to sugarcoat the record. Okay, so I previewed this by saying we would talk a little bit about lessons learned. A few lessons learned. One of them is what I call the slow to build and quick to break problem. Just like a plate. Takes some time to build, is very easy to break. We found that agencies are that way too. So let's build reformers, which is what we were. We were trying to build something, right? A lot of the law was dormant. A lot of the case theories hadn't been tried. We were trying to build something, a bigger, better agency. It's much harder to do that, maybe no surprise, than it is to come in like some of the reformers came in 1980 in the US and just tried to break an agency, right? It's just a lot easier to break an agency than it is to build one. And we're seeing that again under President Trump's second term. They're breaking agencies, and it's easy to do. It's hard to build, though. Drilling down just a little bit, building something usually requires more resources, right? Whereas breaking doesn't. That's kind of the starting point for all of this. Drilling down even further, it's a lot harder to hire people than it is to fire them, at least in the US. It's a lot harder to investigate and build a case than it is to just dismiss a case and end one. It's harder to support the bigger cases that we wanted to bring against the bigger, more powerful defendants than it is to support a narrow case against a less powerful defendant. It's harder to get a pro-enforcement decision to stick in the US because you have to go all the way through the appeals process, fighting a defendant all the way, than it is to get a pro-defendant decision to stick. That's very easy. All you do as the agency is say, oh, well, we're not going to challenge this anymore. And now that defendant-friendly decision will stand, right? Okay. Drilling down even further into the personnel, right? Personnel kind of is policy, of course. It's much harder to outflank your own staff on the left than it is to outflank your staff on the right. And now I'm getting into the very personal part of this talk. Think about yourself, put yourself in the shoes of an agency enforcer. You pride yourself on being an aggressive protector of the people, right? Now, imagine the political leadership outflank you on the right. They shoot down your case. Okay, you go out to the pub that night, you have a pint, you curse the political leadership, and then Monday you're on to the next thing, right? Now imagine political leadership outflanking you on the left. You're saying there's nothing we can do here, and they're saying yes, there is. That challenges somebody's sense of self-worth, right? It challenges your sense of identity as an aggressive protector of the people. Somebody's telling you now that you're not. That's much, much harder. And, by the way, I'm not telling you, hey, go out to the pub, have a pint, Monday you're on to the next thing. I'm telling you, you're going to spend the next year of your life or more doing something that you've just told me you don't believe in. Right, so this is less obvious, I think, than some of the other resource dynamics I described a second ago, but it is much harder to push staff from the left than it is from the right. So, slow to build, quick to break. It is a real problem. Another lesson we learned, though, I think is go big. So we're faced with the choices as regulators constantly. Do we bring a narrower case that's maybe a higher probability of success and will require fewer resources, or do we go big? And at the FTC and at the DOJ, while we were there, we tried to go big over and over. And we did take some losses along the way. But what we saw was we sometimes would inspire our friends, for instance, in the US member states, to act, and they have their own authorities. They can do things too. And if we do a big popular action, then lose, we've at least spotlighted the problem, we've potentially inspired our friends to act, and hey, it's always better to roll in a crowd, right, than it is to do it on your own. So when you go big, you can inspire, you can bring people along with you. Third, though, we learned that structure really is essential, and the structure of the Democratic Party in the US just wasn't there to support us. And we saw that once Kamala Harris became the new presidential candidate on the left. She clearly waffled as to whether to support us or not. She ultimately ended up basically signaling she was going to go with the wealthy donor class rather than these insurgents. And that, I think, cost her the election, frankly, and it certainly cost all of us our jobs. And that's how we ended up out of power. There just wasn't the infrastructure to make it a durable, long-term project. Okay, to close on a hopeful note then, toward a better future, what are we trying to do now that we're out of power? The revolutionaries are out of power, sitting on the sidelines. What are we doing to try to create a better USA, recognizing that oftentimes, as Professor Ng said, what we do in the US has repercussions, right, in the broader world. So it's not just that we're trying to make a better US, we're trying to make a better world, at least at the margins. One thing we're doing is refining ideas. So this is a very young movement still. We need to think through things like disciplinary roles. What exactly is the role of, say, industrial organization economics? Under the previous paradigm, it was everything, right? The lawyers were just downstream of the economists. I'm not one who would suggest getting rid of economics at all. But one of the things we're thinking through is what is the role of economics in relation to the role of law? Because I think there needs to be a role of law, especially in a world where we're looking at a US that's kind of lacking rule of law. We at least need a role for law, and then we need rule of law. Right, so we're thinking about disciplinary roles. We're thinking about metrics. I think we have a good sense for what our goals are, but what are our metrics for success? How do we measure them? Still some open questions there. We're thinking through creative remedies. So let's say we get back in power and we have some tools to wield. What are the solutions? We're pretty good at, I think, identifying problems, but what are the solutions, I think, can be an even harder question than what's the problem. So how to fix it, a very live topic. And a lot more that I won't go into, but we are, instead of trying to build the parachute having jumped out of the plane, this time we're trying to build a parachute factory and get really good at building parachutes. Second, we're trying to do some coalition building. We, I think, have the right ideas. We need the people, right? We need the institutional structure. So, a plug, if anybody happens to find themselves in the US, in Tennessee in May, I'm putting together an event that's bringing together labor unions and anti-monopoly workers. And that's really a kind of conscious effort to build more coalitional infrastructure. Labor unions are the closest thing we have to left institutions in the US. It's been so hollowed out. That's all we have. We need that coalition to be strong if we're going to create a durable change. So, a little step. but a step. We're also, I think, going to try to ignore the haters. While we're building these coalitions, recognizing we need a big tent, we don't need everybody in the tent. This is one of the areas where I probably part ways with my former boss. Lena is so smart and so good at persuading people that she has the right ideas, because she does, in part. She's willing to go on CNBC. She's willing to talk to The Economist. She's willing to talk to the Wall Street Journal, even though they have nothing but bad things to say about her. I think at this point, it's time to just move on, right? Just move past. Those people have class interests that will never allow them to come over to our side. That's okay, right? We don't need to win everybody. I think it's time to just move past them, ignore the haters. Okay, finally, building coalitions, refining ideas. We really also need to build out capacity in the US. And this was something we discovered very, very quickly once we were in power. We just didn't have enough friends at the table. I said we did some popular things that started to inspire some of our friends in the States to do actions of their own, but there's so much more work to be done on that front. And so where do you find Lena now? Working at the local level in New York City. The first thing she did when she got on the mayoral transition team was to comb through the code, look for all the legal authorities on the books that hadn't been used, right? She's done this before now. And there are a lot of them, perhaps unsurprisingly. There's a lot of unused power in the US at the local level, at the state level. And imagine that at scale. We've got a dozen cities doing that. We've got 25 states doing that, looking through their books to find all the tools at their disposal and getting inspired, getting bold, getting ready to actually use them. And that's a lot of power. That's a lot of potential. So trying to activate that, big, big part of a project right now. Local and state, and then as well, private. The private enforcement in the US has been around for something like 120 years. So if you're injured by a big company that has a monopoly, you can sue them in the US. You don't have to wait for a public enforcer. But our private enforcement, like our public enforcement, had gotten kind of brittle, gotten kind of narrow, kind of constricted in its scope and in its vision. And one of the things we're trying to do is to really energize and capitalize on the wave of enthusiasm we see in law school. So I said a moment ago, when we were doing that work of engaging students, it was not just for fun, it was because we need that pipeline of new ideas, new people who are really excited about this stuff, who are gonna maybe go out and start their own creative, light, nimble law firms and be able to bring their own cases. And there are some really, really cool, I can't talk about them just yet, there's some really cool startups that are in the works that are gonna activate that private sector in the US and act as a kind of a force multiplier. So with all that in place, hopefully the next time, and I think there will be a next time, the next time the revolutionaries are in power, they've got a much more expanded group of friends, a much bigger coalition, a bigger toolkit. They're gonna be able to do a lot more. And what we did was so popular, I think when we're doing that much more of it, that's durable, right? That's too big to ignore. It's too popular to target. Okay, that was a lot. A quick recap, and then I'm looking forward to your thoughts, your questions. So first off, it was a really unusual confluence of events that put us in power, frankly, before any of us expected to be. Second, I do think we accomplished an awful lot in a fairly short period of time, recognizing some of the limitations we faced. It wasn't all roses, but there were a lot of big, popular, important wins that happened during that time. That said, we just ended up running out of time. We ran out of structural support. There just wasn't enough there to let us do, I think, a fulsome job. 3 years was, a lot. It wasn't enough. So what are we doing now? We're really working toward building something durable. That requires institutions, that requires coalitions, and a better intellectual framework. All of that's ongoing. A hopeful note to end on. Thank you so much. Looking forward to your questions.
Thank you. Professor Newman, for your lecture. Lots of insights, lessons. Was it a bit therapeutic to write that?
It was. Thank you for letting me do that.
Well, now we'll take questions from the audience. Please raise your hand, and an MLS member will bring you a microphone. And please wait for the microphone before you ask your question. If you can first state your name, your organisation, and ask your question, that would be great. So I guess that gentleman there, thanks.
Yes, thank you for a very informative speech. My name is Peter Clark. I'm a barrister, but I practice in the privacy area quite a bit, and I follow the FTC announcements and their announcements of various enforceable undertakings for some time. And I've noticed in a lot of ways they are very positive in terms of enforcing enforceable undertakings against quite large organisations such as Facebook, and they've imposed massive fines which only our regulator here would dream about getting, and over a 10 to 20 year period. So, you know, I quite admire the approach of the FTC, but I do wonder, because often the basis of those enforceable undertakings on the basis of a misleading and deceptive conduct, to use that phrase in Australia, that they gave undertakings as to maintaining security of data or things like that, and they didn't follow through. I worry that sort of, was it an intention of the FTC to step into the privacy data security sphere to fill a lacuna in the law? Or, well, it looks like you've answered my question. or was it, and was that because there was a failure to have a privacy regulator in America? Because I know you've got COPA and a number of other legislative areas that deal with some form of privacy, particularly in health and protecting children, but there's no regulator. And is that a very healthy way? If that's the case, is that a healthy way of approaching public policy, that you feel there's a gap in the law and you have to step in to fill that gap, but it's really not, you know, in your wheelhouse, so to speak?
Yeah. So two really, really great questions. I think, yeah, still not good. First off, was it intentional? Yes, I think absolutely the answer is yes. The US privacy regulation landscape is patchwork. I think it would be probably the best way to describe it. There are some great laws on the books, but it's not uniform at all. There's no designated regulator, no designated enforcer. So there's been a very concerted, very conscious effort by the FTC, and as you said, going back longer than 2020, certainly. I would say back to like 2015 or so, to really be much more active in enforcing and protecting privacy. There are a few state laws on the books now, but those are pretty recent. So yeah, I think it was a conscious effort by the closest thing to a privacy regulator that we really had, the FTC, Federal Trade Commission. As to whether it's a good move, so if somebody sees a gap, moves to fill it, even if they're maybe not the perfectly situated enforcer to do it, it's something I've thought about a lot, both on the privacy side of things, but also on the competition side of things. There were certain things I didn't get the chance to talk about, but thanks for the opening, that we did on the competition side that were pushing the boundary, right? So prohibiting certain contractual terms just across the board. At least in the US, that was not viewed as the role of a competition regulator, but we did it anyway. I don't think it's perfect, but I think it's better than nothing, right? And if we just sit around and wait for the US Congress to act, nothing's gonna happen. If we try something, the court system can act as a check in the US, so they can shoot us down if they deem it appropriate, and they have for some of these actions. But then I think that can act as an important spur for legislative action. And now we've fixed the problem, really. So if you view it as more of a dynamic dialogue between the agencies, the courts, and the legislators, then I do think it's a pretty good solution to an imperfect world.
Thank you. Janne?
So, my name is Janne Svetjev. I teach at the University of Sydney Law School, and I guess I wanted to invite you to kind of like share with us some of your reflections on one of the points that you raised at the end, which is the question of remedies, right? So, you know, if the movement, as you described it, you know, was concerned about the concentration of power, it also needed to have some kind of a credible project through which basically companies could be broken up. Most of your examples in the talk were about mergers, and I guess that's kind of like, preventing further concentration. But that doesn't really tell us, whether or not there is a kind of credible way to reduce concentration of existing companies. And I wonder whether that actually was one of the reasons why, companies were willing to take on the challenge. So, if you think about the Google litigation, the problem is that now there is a kind of impasse, in the remedial thinking, and of course it's a different administration. But if you were still in power, do you think that the remedy that is being kind of contemplated is actually a credible deconcentration remedy?
Yeah, so for those of us not acquainted with this Google case, it was the first big US case, really, against a big tech company. Filed under President Trump's first administration, actually. It took a long time to get through the court system, but finally yielded a win, and everybody was really, really excited. Wow, this is a US court saying Google is a monopolist. It's violated the law. Surely now it's going to get broken up. The opposite happened. We got a remedy that's very narrow. It requires Google to do a little tinkering around the edges, but the government had been asking for things like spin-off of the Chrome browser, potentially selling off the Android operating system for mobile, which would have done amazing things, I think, for the ecosystem. The judge just wasn't willing to entertain any of it. And I think that speaks to, frankly, another area that I didn't mention that is a pretty high priority for us to fix, which is judicial education in the US. Our judges still, so many of them, just view the world through this kind of neoliberal lens, and I don't even think they realize they're doing it. It's just the water they swim through. Changing that, whether it's through changing the pipeline, so educating law students, or creating more judicial training opportunities that would counter some of the right-wing judicial training we have, I think that's got to be a part of this project, because otherwise we can bring all the big cases we want, and we have. And we can ask for all the big remedies we can dream up, and we have. But if a judge won't do it, it leads to a really disappointing outcome.
Thanks. Anybody else? Philip?
Philip Williams, ACCC. Do you see, from somebody living outside the United States, it appears that the attacks on the DOJ and FTC in recent years are rather similar to the constraints that have been placed on the CMA. Do you see any similarities?
Yes. The US DOJ in particular just seems to have had its wings clipped, basically, in the US. It's a little bit different than the CMA in the sense that the US agencies seem to still want to be talking about the same things that we were talking about. They're using the same language. The CMA has clearly shifted its tone in the way it just talks about its work, I think. Whereas the US agencies are still talking the same way we were. But when you look at the actual enforcement record, it's much, much smaller caseloads. It's much narrower cases. It's more ideologically driven actions rather than, we see an actual concentration problem. So I do see some similarities in the actual results here, but curiously enough, perhaps because in the US, the right political party has realized what we were doing was popular. We're still seeing the same messaging in the US that we were seeing before. So it's kind of an unusual situation. I see some similarities, absolutely.
I'm Robin Chatwood. I'm a partner in a law firm, Denton's, specialising in technology. I'm very interested in the intersection of technology and competition law, and particularly things like dynamic pricing and how the FTC or the DOJ should be dealing with those things. I'm also observing the current administration viewing the clamps that perhaps the Europeans want to put on AI and those sorts of tools as kind of anti-competitive in some ways. But I think that there is obviously a balance between, fostering innovation as well as, ensuring that we don't get the worst of innovation. Can you comment on, the general focus on that? Do you think that there's a role for international law when it comes to, you know, some of these really big conceptual challenges that we've got with technology and competition law?
Yeah, a big question, or set of questions, I guess. I would like to think so. I would like to, starting with the last question first, I would like to think there is a role for if not international law, at least international dialogue, because I think we are all looking at a very similar set of problems. Some differences, of course, but generative AI in particular seems like the kind of technology that's actually real. It's not, you know, it's not crypto. It's a real technology that's really changing our lives already on a day-to-day basis. Some of that's good, but we're already seeing, I think, some troubling competition dynamics where when one company announces, hey, we're taking the safeguards off our AI chatbot, other companies apparently feel pressured to do the same. That's not competition doing good. It is competition, but it's competition doing bad by society. And that's a market failure just as much as a lack of competition, I think. So I see an absolute role for international dialogue around this. Otherwise, I see a continuation of what's going on right now, a race to the bottom where we have an extremely harmful technology in certain applications. I'm thinking not just of deep fakes and non-consensual pornography, but of getting back to the sort of privacy questions, scams, fraud, all of this is massively inflated. And at least in the US right now, all we've seen is the Federal Trade Commission asking for a less of a budget for consumer protection work. We're doing the opposite of meeting the moment. So I'm not looking to the US to solve this problem, which means it has to be an international conversation, absolutely.
Does competition law have any role in relation to organised labour?
Yes. I have a definitive answer to that. 5 years ago, I would not have. Other than to say competition had oftentimes been used to harm organized labor in the US, going all the way back to 1890 when we first got our competition law, the Sherman Antitrust Act. The very first cases were attacking labor unions. In fact, Eugene Debs, our most famous socialist, once was a target of a competition case. So there's a long and really troubled history between organized labor and, you know, sort of loosely organized labor and competition law, up to the point that in the 2010s, the Federal Trade Commission had been threatening groups of like part-time music teachers who were just trying to organize for slightly better wages. That's what we're using our competition, the full force of the US government, that's what we're using it to attack. So we had gone horribly astray, I think, from the original vision, which was prompted in part by organized laborers. They gave us our competition laws. It was a coalition of organized labor, farmers, small business owners who gave us the world's first competition law. Right? And then we immediately forgot about that and started attacking those same groups. So I think the role had been very antagonistic. As of 2024, we got a federal judge to say, in a case challenging the merger of Kroger and Albertsons, this would be the Woolies and Kohl's roughly in the US, we got a federal judge to say, you could define a market, you could identify a market for unionized grocery labor specifically. So this judge was willing to entertain that theory, to say, I will protect that. If you can prove that you have the facts, I will protect that as a defined market. So that's a pretty radical shift, I think, in about 5 years. So now there is absolutely a role to be played if the enforcers have the will to see it out.
But a further question is, what if organised labour are abusing their power? We've got a single union screwing the whole of the state in Victoria in major building. No one's doing anything about it.
Well, so this is one of the areas probably where the US and Australia are quite different. We have probably the world's weakest labor laws. It's extremely hard to form a union, and they're highly constrained in what they can do. So we're far from the point where I think we need limiting principles, at least in the US. Right? I think we need to build, we would need much more union density and much more freedom before I would see any potential for abuse. Frankly, that's just where things are in the US at least. In the US, labor, though, does have a unique exemption. So they just can do things that other types of economic entities cannot. And I think that recognizes some economic realities, right? That there just are frictions in labor markets. There is a natural imbalance of power between an employer and a worker that necessitates some legal correction. So I think it's appropriate to allow some space there. Now, I won't comment on the particulars of the Australian situation because I don't know it well enough to, but at least in the US, we have a long way to go before I would start worrying about the abuses.
I'm just conscious of the time, so just 2 more questions. Down here. Yep. You're the second last question. I get the last question. Yeah.
You talked, I mean, we're acknowledging that the market concentration is growing globally. I think there's plenty of research on that. You talked about the appetite for youth and discretion to enforce in the US, and you brought that with your time there. We talked a little bit about legislative definitions, our substantial lessening of competition, and whether creeping mergers and things like that, and judicial interpretation. Are we missing something globally around maybe a public mandate and an understanding perhaps of the damage that the lack of competition is doing to us, whether we're talking productive, dynamic efficiencies, all of those kinds of things? But are all of these things that we're talking about here perhaps missing the thrust from the public due to our moment not sort of being here yet? Is there things that we can be doing differently to sort of back those things that you're talking about up?
Yeah, a great question. Maybe just a couple of thoughts. This could probably be an hour-long conversation, and I would look forward to that. Couple of thoughts. One, substantial lessening of competition is generally the standard that most competition authorities around the world apply when they're reviewing a merger. Which means if a merger or acquisition lessens competition, it deadens competition, it stifles competition, but it doesn't do so substantially. So it just kind of lessens competition. We let those go through. We have to. I think that might be a problem. In the US, we forgot about our other prohibition, which also says we have to stop mergers or acquisitions that may have any tendency toward monopoly. I don't care if the tendency is that big, right? That, for some reason, didn't make it into a lot of other authorities around the world, but we're working pretty hard to revive that in the US. California just took up a bill that would break that out and say this is its own prohibition on mergers. I think that's an important thing to maybe think about. And then second, so substantial lessening of competition. Second, I think we need to think about having more public interest standard type merger review around the world. I'm thinking in the US of the example of 2 famous movie studios, Paramount and Warner Brothers, makers of Hollywood classics for decades. They're merging right now, and there's no obvious need for them to do it. The buyer's going to saddle up the target company with a ton of debt. It's going to be less able to make good movies that people want to see. There's no reason for that merger to happen. I think everybody agrees it's going to harm the public interest, but I'm not sure we're going to be able to stop it because I'm not sure there's substantial competition there. So, public interest review as well.
Final question right there.
I'm Arushi, and I'm an economics student that does research in industrial organization. So my question is a bit jumbled up, but what I want to try and talk about is from an enforcer point of view, do you see that there is a gap between applying economic theory and applying legal theory? And if that gap or that tension is sort of one of the reasons why there were certain losses that the FTC went through?
Yeah, I think it's a wonderful question. I think a couple of different gaps. One, I will say, there's been something of a caricature of the economics profession that certain people who are loosely affiliated with my movement have leveled. And I think those are unfair. I do think economics has improved immensely since the 1980s, right, as a discipline. That said, one of the gaps I think we still struggle with is anything having to do with long-term dynamics and effects. It's just not in the typical econometric toolkit to come up with a way to measure those, right? So I think that's still a gap. And then second, at least in the US, we, for way too long, focused too heavily on theory, and the models are wonderful. But we lack really good empirical evidence on how a lot of these laws actually affect real markets. So that's been a real focus, I think, in IO in the US recently. And it's amazingly helpful for enforcers to have that kind of data, much more so, candidly, than a complicated math model.
Thank you very much for answering all the questions ranging from privacy law, labour, big tech, and your thoughts on the current Paramount Warner. I was going to ask you about that anyway. So thank you very much. We do have a tiny gift for you. Thank you very much.
Thank you.
And thank you very much for everybody for attending. I want to specifically thank Emily, Anna, and the rest of the events team for helping to organise this event. Thank you for joining us this year, and I hope to welcome you back for the next lecture. Thank you.